Yes, Mr. Barrett.
Mr. Barrett, yes. Good morning, my lord.
You're for the appellant this morning, and Mr. Harland is for the Secretary of State. Right, as you can see, we're in court with some new technology, so you'll have to forgive us if we, or I, seem a little bit slow. First of all, I want to say, have you had a chance to discuss how long you're going to take? And dividing your time. Mr. Barrett, how long are you going to be?
I doubt I'll be longer than an hour.
Right. Well, that's a good sign. And Mr. Harland, how long are you going to be?
I think no more than 45 minutes.
Okay. All right. Well, then you're confident of finishing before the short adjournment.
Yes.
And we'll see if you're right about that. And now, Mr. Barrett, we're not particularly happy with the state of the bundles. What do you want to say about that?
My lord, yes. The bundles were helpfully prepared by the Secretary of State solicitor because, as you know, I'm presenting on a direct access basis, so my client was unable to, well, it wasn't that he was unable to put the bundles together, but it was far more appropriate that the respondent put the bundles together. So they were prepared in that manner. I do apologise for that. That was what was agreed between the parties.
Well, we'll see how we go, but at the moment we're to say the least, in a state of some irritation about them, and the pagination is not entirely clear, and I'm not sure the electronic pagination is going to tally with the paper pagination. As you can see, you're going to have to deal with both. All right, so thank you for that. Where do we go to start off with?
Well, yes, I mean, may I just check, because there may be issues with the bundle, that you do have the replacement skeleton, because that was filed over with the appeal bundle. I'm grateful. And, and there was also an application by the Secretary of State for further documents to be adduced. They were the G-SID notes, the disclosure notes, and hopefully you have copies of those.
We have. I think we're going to spend quite a lot of time looking at those. Can you deal with a preliminary point for me?
Yes.
Because this is, may not be the first time I see them, but as you all appreciate, unlike my colleagues, I'm not entirely familiar with this material on a regular basis. If we look at the GCID sheets, does the date come at the top of each entry or at the bottom of each entry?
The dates come within the documents themselves. So the top, my understanding of the notes is at the top is when they're printed off. So
that doesn't help me. So if we were to look, for example, to the page where I think we're going to be spending some time, page in 17 to 24 of the document, of the sheets, what may be page 30 of a paper bundle,
yes,
and is page 52 of my electronic bundle.
Right.
Just to give you a flavour of.
And it says page 17 of 24 on the top right.
17 of 24.
Yes.
Okay, so if I look at the entry
yes.
in the middle of the page,
yes.
which begins BF to 19 August 2019, email response required, post-decision case taken over from previous post-decision CW, according to notes, etc.
Yes.
You with me?
Yes.
When was that note written?
Well, I'm not sure, but I took it as being the 10th of June.
Well, if you're not sure, Mr. Harland should know, because they're his documents.
Yes. My lady, I hope I do know. The answer is that it's in fact the date below. Oh. So that would have been entered on the 12th of August 29. One can perhaps see this, for example, in the entry on
it's probably the entry on the next page, page 18, because it appears to correlate with the letter that's been sent, the date, the 29th of August.
My lady, yes, I was trying to turn up an example of that. One can see that there are entries which can only correlate to the date below the entry and not the date above.
Okay, well then go to the last page. On page, I say the last page. It says 18 of 24.
Yes.
That's the last page here.
That's the last page that we have, yes. There are replacement pages, which I don't know if your lordship has, which go between pages 8 and 14.
Yeah.
But those are unredacted. But the last
We'll
page
come
we
on to
have
that in a
is
minute.
page
But,
18.
so when it says page 18 of 24, it's not page 18 of 24 because we don't have pages 19 to 24.
There are 24 pages in a document somewhere, and this is
Well,
a relevant extract.
And you see, if I look at the bottom of page,
Bizarrely, I've got pages 19
Have
to
you?
24.
Where?
I haven't.
Yes.
In one of the many extracts that
Oh.
I've been sent in the last few days.
You see, the reason I was going to that was if you're at the bottom of page, the last page we've got 18, there isn't a date.
Yes, but that date flows over onto the next page. So there will be a date on the following page.
I think these. So when did you send? There was a separate email, wasn't there? It came through the day before, a couple of days ago. Are you saying that has the?
Yeah, it does.
That has, I naively assumed, Mr. Harland, that I was just because I got several copies of the same document. This was another copy of it, but it isn't.
My lord, for my part, can I apologise for the confusion in the bundles? It is right that my solicitor volunteered to assist because Mr. Ullah himself was struggling to put together the bundles. But she could only do that with the emails that he was sending her and the extra requests that was being put in. So it's deeply unfortunate, and we regret that the bundles are in a confusing state, but my solicitor was trying to do what she could to assist the appellant, whose role it properly was.
Okay. Well, I've now found pages. I've now looked at the missing pages 90 to 24, and they do show. The last page shows a date at the bottom, so that supports your interpretation of these documents.
My lord, yes. I've had some experience with these documents. Unless the system has changed, or unless my memory is very, very fallible, it is invariably the case.
I'm making a note. Mr. Holland assured the court that the date, the relevant date in the GCID notes is the date underneath. Yep.
Mr. Harland, as you're on your feet and we're dealing with these notes, I'm not asking for an answer now. When we're looking at page 17 of 24, there is a reference there which, using your the relevant date is the one underneath, appears to have been made on the 12th of August, and it says, according to notes, during the compliance visit, the sponsor told the compliance officers the post was no longer required. I have tried and failed, but that doesn't mean to say it's not there, to find the date of the compliance visit.
Yes, I have taken instructions on that. The compliance visit was in July.
When? All right, no need for an immediate answer. You can check it out, Mr. Harland, but that's when it was it?
Yes.
Well, where's the evidence?
But,
Is there going to be evidence? Is that agreed between the parties?
well, my lady is entirely correct. It's not in the GCID notes anywhere.
So this is an assertion you're making, having made an inquiry.
Those are the instructions I've received.
Have you discussed this with Mr. Barrett?
It hasn't been something that has been asked of us because the precise date of the compliance visit hasn't arisen. But I didn't intend to raise it independently. But I'm sure Mr. Barrett wanted some time to reflect on that, and there wouldn't be a difficulty. And I can take instructions as well, my lord, if it would assist.
I mean, this was a leave application, wasn't it? We're dealing with here,
Yes.
and this where there's an uncertainty or dispute of fact, in these circumstances, on what basis does the court proceed?
Well,
As a matter of general principle, on the basis of what the appellant says, or what the applicant says, or what the Secretary of State says.
the general principle in judicial reviews is that if there's a disputed fact, that it be resolved in favour of the defendant, the respondent, and that would be the underlying principle here. But we accept that we are in slightly different circumstances because this is a permission. So this is an appeal hearing, but against a finding on permission. The reality is that if permission had been granted, then evidence would be supplied by the defendant thereafter. But at the permission stage, that is a stage prior to the detailed grounds being filed by the respondent here, and the evidence being supplied as a result. So.
All right. Okay. Well, after that preliminary skirmish, we may come back to all those points. Let's go back to Mr. Barrett.
My lord, yes. Yes, the fundamental point on appeal here is revolves around fairness. We say fairness for the appellant, and there's 2 points really that were made in respect of the fairness. One was the delay point, and secondly the procedures, the process, procedural fairness in the decision making by the respondent. In terms of considering fairness, of some importance, we say, is the context in which that fairness needs to be considered. In the context of, on the one hand, the points-based system, of course, the rules in place. We're not putting a direct challenge on the points-based system. But on the other hand, the facts in respect of the appellant's circumstances, the background to his application. And you will see there was more than one application that was made as a precursor to this application. So there was a first application that was made, which was refused, and that was the leave to remain. That was the extension application when the appellant had leave to remain. So he had leave to remain. He puts in an application prior to his leave expiring. It's refused because his salary is too low.
Would it be good just to get the chronology, the bare bones of the chronology, clear in our minds?
Yes.
Okay. So, your client originally applied in 2014.
His original leave to so yes.
And it was granted.
Yes. Granted, and from 20. Granted until the 27th of May 2018.
Just a moment.
No. Let's carry on.
Anyway, the basic chronology I've got clear.
Yeah.
And tell me if it's wrong. Is that your client was granted leave to remain on the 29th of May 2015?
Yeah.
Until the 27th of May 2018.
Correct.
On the 25th of May, 2 days before it expired,
Yes.
he applies
Yes.
for leave to remain as a Tier 2 skilled worker. That's how he got it before.
Yeah.
Okay?
Yep.
And on the 24th of July, that application is refused because the salary was below the salary requirement. The salary offered by the sponsor in the certificate of sponsorship.
Correct.
So he didn't have enough points.
He didn't have enough points.
Okay. He applied for a review, administrative review,
He did.
and that was refused on the 22nd of August, 2018.
Correct.
And at that point, he became an overstayer.
He did.
And therefore, at all times thereafter, he was an overstayer.
He was.
And then on the 30th of August, he applies again for leave to remain, same basis, Tier 2 skilled worker, with a new certificate of sponsorship.
That's correct, yes.
With a salary that satisfies
Yes.
the requirement.
Yes.
And how long was the certificate valid for?
3 months.
And just help me with this, Mr. Barrett. What after the certificate of sponsorship expires in these circumstances? What are the consequences?
Well, I've had a discussion with my lawyer friend about this because I think my replacement scale might be slightly misleading. Even though there's a validity for 3 months, in effect, it doesn't stop an individual from working after the validity is expired. It doesn't expire. So as long as that certificate of sponsorship is placed in an application within 3 months, with a start date of 3 months from the date of application, then the certificate of sponsorship can continue. So in other words, it does allow for further time to be taken on an application.
Is that an agreed proposition?
It is, yes.
Is that in statute, regulation, or authority?
I can take the court to the guidance.
Okay,
which
it's the
is
guidance.
allowed.
Okay, thank you. That's helpful. Thank you, Mr. Hunt. Could you make a note that, not now, but at some point, I'd like to have that for my notes. I'm sorry if I'm going slowly, but the convoy has to move at the pace of the slow ship, Mr. Barrett. Okay? Okay. Then, on the 10th of October 2018, it's refused. Yeah?
Yes,
On the asserted that the salary is below the requirement.
yes,
You lodge a review application, and then on the 19th of November, the refusal is withdrawn because it's been made on the basis of the error, namely that the Secretary of State considered the first application when the salary was below the requirement, as opposed to the second when it was
yes.
satisfactory. Okay, and then so that's the background, and then we come to the period which we're going to be hearing more about, no doubt, of delay until the 29th of August 2019, when the application is refused.
Yes.
Okay, and on the 30th of September, the admin review is refused. Yep.
Yes.
And then on another date I've got here, the 30th of October, the compliance officers revoke the sponsor certificate. Okay. Now, two dates I'd like to know if you can help me. First is, is there an agreed date on which the sponsor's license was suspended? No. What do you say the date was?
We say it was after. Well, we don't know. We don't know the date. We don't know the date.
So the appellant doesn't know the date when it was suspended. Sponsorship license was suspended.
The nearest we seem to have in the documentation is again page 17 of 24, where we've got email received from the compliance officer, the sponsor's license has been suspended, and again going on the basis the relevant date is the one immediately below, that's the 27th of August, so it precedes the letter that was sent to the appellant, and that appears to be borne out by the entry on the next page, page 18. Application refused on no COS, sponsor withdrew COS, new COS was applied at time of refusal, in brackets, sponsor has been suspended, not mentioned in the RFRL, which I understand to be the reasons for refusal letter, and that is dated the 29th of August, which would be consistent with the date of the refusal.
Yes.
And no doubt Mr. Harland can assist the court when it's his opportunity to do so.
Yeah. So there are two dates. The first is when the license was suspended, and the second date is when did the sponsors inform Secretary of State that the post was no longer required.
Yes. There isn't a clear date on that either when the sponsor informed the respondent. There seems to be a suggestion that there was a discussion that took place during a compliance visit, but I'm not sure there's any certainty on the date.
Well, should we look, and if my lady will forgive me, again, it's the slowest ship in the convoy, me. If we look at page 17 of 424.
It looks like 12th of August.
No.
No.
Well, it doesn't
No,
look
it
like 12.
doesn't.
That's the problem. That's the date in which, you see, read the whole thing. BF to 19th of August. I don't know what that means. Email response required. Post-decision case taken over from previous post-decision case worker. According to notes, during the compliance visit, the sponsor told the compliance officer the post was no longer required.
But then the author of the note says that that's ambiguous. So there are two ways.
I'm not sure if they mean an account. Yeah.
So they've asked, they then contact the sponsor to clarify that ambiguity.
The job is no longer available. Okay. Yeah, but yes. But the 27th of August entry, again relying on Mr. Harland's assurance that it's the date underneath. Email received from the compliance officer. So that's within the department. The sponsor's license has been suspended. The sponsor also confirmed the job is no longer available. We don't have that entry doesn't tell us when the sponsor said that. I think. And there's nothing in the note above the previous notes to indicate when the compliance visit took place. Is that right?
That's right.
Okay, thank you very much. Right, so that's helpful to me at least. I hope to everybody. How do you want to develop your argument?
Can I just go into that chronology with a little bit of flesh and bones, if I may, because I think it's important to consider at certain points what did occur. So following the application for leave to remain that was refused in July July 2018, the appellant puts in an administrative review, got that far, but within that administrative review, so this is the initial application that's refused in 2018, he places a certificate of sponsorship with that administrative review, asking the Secretary of State to consider the new certificate of sponsorship with the appropriate salary in it. There's a bit more detail within the administrative review setting out why that's included, the certificate of sponsorship, but effectively there's an explanation within that administrative review about the increase in salary. A short explanation, but it's an explanation.
Yep. Just so I understand,
Yes.
what is the significance of that point going to
The
be?
significance of that point is the respondent, when they refuse on the administrative review, so when they say, sorry, we can't take that into account, they say to the respondent, make a fresh application.
Yeah.
So we say they're on notice, the respondent is on notice at that stage. They know what the issue is in terms of why, of course, the application is refused, and they know that the appellant has obtained a new certificate of sponsorship with the appropriate salary.
That doesn't affect your client's status as being an overstayer from the moment the administrative decision review is refused.
It doesn't, but he applies within 14 days as an overstayer, so he's entitled as long as he puts in a new application, a fresh application, within 14 days. It doesn't give him leave to remain, but it entitles him to have this fresh application with the certificate of sponsorship considered. So that's the first part. The second part is that this wasn't, when we say fresh application, this wasn't a initial application for employment for the first time. The appellant had a background of employment in the same position for the same sponsor. And we say that's all important contextually when one looks at other cases, and that, but we say those are important matters.
But equally, none of that affects your client's status as an overstayer.
Well, it affects his status as an overstayer, but it does affect how he looks at the application and how it's to be determined. He takes the view that, so his position on when he puts forward that application, how it's going to be dealt with. He does what he's asked to do. He puts in a fresh application. He includes certificate of sponsorship. So
one of the things, again, speaking as someone comes to this area of the law with something of an outsider,
yes,
it's, I suppose, unsurprising, but always notable that how late these applications are put in.
yes,
I mean, this application was put in 2 days before his original leave to remain expired.
yes, that's correct.
And the consequences of that are that it puts him at risk of becoming an overstayer through the operation of the law.
Correct. That is yes. He put it in very late. That's correct, and therefore it was an error that couldn't be dealt with administrative review. Very few hours can be dealt with on administrative review. Then he's left with making an application as an overstay. But there is a difference, and this is why we highlight it, between an individual who has a history, and this is effectively an extension application, even though he didn't have leave to remain. It's effectively the same position, the same employer, so that matters, we say, than somebody who's putting in a new application. Because, for instance, if he was a student and then puts in a fresh application to Tier 2, that would be somewhat different to an individual who has a history of working for the same sponsor in the same position. So that's why we say the context is important.
What effect does the context have on the substance? I'm not really understanding a submission.
Well, on the substance itself is that, in terms of because of the delay point, ultimately, because of the time the respondent takes looking at the application itself. This is a person who was known to the respondent and a history of employment. So the time period that's taken to consider the application, which we say is excessive and unlawful because it is so long, has to be judged against the background and the context of the application that's made. Also, the fact that the appellant was in a position of being an overstay, as you say. This was likely to be his only application that needed to be considered properly and fairly because of the position was that he didn't have leave to remain. So in other words,
Well, I think the lady wanted to know how his status as it were, what you're calling a renewal applicant, affected the substance, and I not quite get the moment how it improves his arguments on delay.
Well, there's a further step that occurs that of course is the error that's made. So that's also part of the context. So it's not just that he makes the application. It's not just that it's effectively on the same terms as his previous application, and it's effectively an extension application. But it's also then there's a case working error, not his fault. Respondent makes an error on his application, his second application, that leads to a delay of 2.5 months.
But by the time the error was made, he was already an overstayer.
Yes. Yes, he was already an overstayer, but with a valid application.
Well, that begs the question, doesn't it? Secretary of State would say it wasn't about it was an on the face of it a valid application because the requirements in the Tier 2 scheme were met. But are you saying it was also an application that should have been granted by the Secretary of State?
Yes. So at first blush, considering it in a prescriptive way, yes.
Well, what does that mean?
Well, in the terms of that on the face of it, he satisfied the requirements of the rules. He had the appropriate salary.
Right, let me just get a note. So on the face of it, he satisfies the rules. But does that mean the Secretary of State is obliged to grant the application?
No. We accept the Secretary isn't obliged.
Right.
And one of the rules that is pointed out by the respondent is correct, that if the rules allow for circumstances where the respondent may investigate whether or not a vacancy is genuine or not.
Yeah.
So they're not obliged, but they need to have reasonable grounds in order to undertake those checks. And then they can seek further information from either the sponsor or the applicant.
Well, it's not part of your appeal that they didn't have reasonable grounds, is it?
No, that's not our appeal.
So we proceed on the basis that they did have reasonable grounds.
There was a leap in the salary
and the structure of the company.
Yes. That was what was looked into. Initially, there wasn't an issue raised about the structure of the company. I don't think straight away. Maybe wrong, but that seemed to come out more following the investigations or the questions that were asked about the company. But ultimately, it was the salary leap that led to the inquiries.
Because one way of reading the explanation that was submitted with the application for administrative review is that the sponsor was saying, oh, if we'd realised we had to pay him more in order for him to get leave, we'd have said we were going to pay him more. I mean, doesn't that raise a question mark?
Well, it may raise a question mark about the sponsor's conduct. Yes, it raises question marks, but it's not. And certainly may be an issue that's worth that may need to be looked into. We don't dispute that.
Right.
Okay. So we've accepted there are reasonable grounds for an investigation and things that needed looking into.
Yes.
Okay. Now, do you want to develop your argument on delay then?
Yes. So my argument on delay is that the respondents, by making the initial error that they make, causes a delay. So they're at fault. And that's the first point. So So
Well,
but that's an important point.
You mean the salary error?
Listen, yes, it's
Okay.
that's
They were looking at the wrong COS.
they're looking at the wrong instance. COS.
Okay.
That's we
So from the 30th of August to the 19th of November.
yes.
Okay, so that effectively
That's a
12
that's a-
weeks.
sorry.
12 weeks.
Yes. So that delay occurs because of the fault of the respondent, not the fault of the appellant. And
But aren't we looking at the delay after that? Isn't that the delay you're complaining about?
no, we're looking at that. That is well, we are looking at the delay after that, but that was also a delay. But we are looking at the delay after that. But it's in the context of what has occurred as to how much time the respondent then took in investigating or asking the questions that it needed to do of the first point of the sponsor. So
Is the essence of it this, that having, through their own error, created a delay of certainly 2.5 months, it was incumbent on the respondent to use all expedition in processing the application of the appellant? Is that it?
that's it. I'm grateful. That is. But instead, we say the respondent ignored her error, ignore what that yes, they say we considered the wrong certificate of sponsorship, but it's then the actions they then take after that, and they certainly don't act in an expeditious way at all.
Okay, so supposing they'd completed this within 2 further months, by end of January, say whatever,
Yes.
and reached the same conclusion, what would your remedy be?
Well, if the conclusion would be a decision, presumably, so they would have made an early decision. So they'd have made a decision before the sponsor made a decision.
Yeah.
And that's the difference. So at that stage, the respondent could have said, "We're refusing the application." They didn't.
Yeah.
Or-
And my question was, supposing, because your point at the moment is it's focusing on the delay, not the substance of the decision. So if they reached the same decision after 2 months instead of a further 9, or whatever it is, what remedy would you then have?
Well, if the decision was a refusal, then again there'd be no remedy other than judicial review.
And what so how then does delay add to your case?
In terms of the remedy, or in terms of,
Well, yes,
Well, in terms of the underlying illegality
yeah.
of what the Secretary of State's done,
well,
how does the delay make what the Secretary of State did on your case any more unlawful?
it gives rise to a set of circumstances that we say prejudice the appellant, because he was expecting, he as I said, going back to the context of the case, he worked for this sponsor before, worked for the employer before in the same position. Because he's an overstayer, he's not entitled to work in that position. This is a vacancy that we say needs to be a decision made about that vacancy made in an expeditious way. You can't just sit vacant.
But forgive me, Mr. Barrett. If am I right that once the application was refused, that was it so far as your client was concerned, because he was an overstayer?
If it had been, yes, if it had been subject, yes, effectively. If it had been
So how does the delay add, as Milady says, to your case on illegality?
well, there's a certain overlap between the delay and the procedures that are taken by the executive state. So it's, but the longer the delay, the more likely it is that there'll be an adverse decision, we say, from the sponsor.
Adverse meaning?
Well, that he withdraws the certificate of sponsorship, which is why ultimately the application was refused.
The longer the delay, the more likely it is that the employer would withdraw certificate of sponsorship.
Yes, I mean,
So that goes back to the point you made, that had the decision been made within 2 months, it would have been before the sponsor made the decision, which the sponsor made, although we don't have the documented time.
yes,
But it would appear to be around July.
yes.
Is that it?
That's it. The sponsor, we say the sponsor can't be expected to wait forever in terms of the application that was made, and the respondent should know that.
If the application was refused and there was no administrative review, and would you what I go back to my question, what remedy would you then have? What action could you then take if the sponsorship had not been withdrawn? Could you make another application?
No, because he wouldn't have been within 14 days. It'd be an overstay. So as an overstay, you can't then make a second application.
So then, how does the fact that the longer the delay, the more likely it is that the certificate will be withdrawn affect your case, your argument?
Well,
Add to your argument.
well, because the circumstances have changed, and so what we say the respondent should have been. The longer the delay, the more likely it was. We say that a sponsor would withdraw their sponsorship. The respondent should be aware of that, or there's two parts to it. It's also apparent. Now, wasn't necessarily apparent at the time, but it's apparent that the respondent was considering suspending the sponsor's license. There is an element of jeopardy, of course, for any applicant who applies, and in the sense of that there's two things that could happen. The sponsor could withdraw the sponsorship, or the respondent could cancel the sponsorship. That's the element of jeopardy, and that's why we say.
Well, the respondent doesn't cancel the sponsorship. The respondent cancels the sponsor's license. Isn't
Sponsor's
that right?
license, I apologise.
Right. Okay.
But those are the elements of jeopardy for the appellant, and that's why it's important that an application such as this shouldn't have been subjected to delay. It was already been and that's why I go back to the first point. It had already been subjected to delay, the initial delay.
Okay. So what you're saying is that the longer the delay, the more likely it was that the sponsor would withdraw sponsorship,
Yes.
and that would be it as far as your client was concerned.
Once that had occurred, or that the respondent may take action themselves, which of course they were considering around the same time, as the sponsor was considering withdrawing the certificate of sponsorship. The difficulty is, of course, is that once the employee starts to be investigated or starts to ask questions on numerous occasions, so there wasn't just one occasion, there was a number of occasions. The actual commencement, the sponsor's first response was in March 2019, and then there seems to be some further correspondence after that. So it does take, we say, it's undue delay following the sponsor's responses. Of course, the applicant the appellant knows nothing about that. He's blind to all of that. And so we say in those circumstances, the respondent needed to get on with it.
Right. Do you want to take us through the GCID records to identify any specific point where the delay was egregious or prejudicial? So just to clarify what I mean,
Yes.
what the respondent says is, well, I was carrying out reasonable inquiries during this time,
Yes.
and it was a complex case, and in those circumstances, the delay wasn't
Yes.
unreasonable.
So yes. So
So, assuming that argument, where do you say she's wrong?
certainly we say from one looks at page 14.
Okay, so I'm on I'm 14 and 24.
14 and 20. Yes. says, I think 2/3 of the way up, on the 22nd of March 2019, this email was received from the sponsor. Emailed over company accounts and Safi Ullah's 12-month wage slips. It also says towards the bottom, other, already emailed over in previous emails. So it seems to
I think we should look at the previous pages, actually. So let's look at the whole thing briefly. Do you agree? On the start.
Yeah.
Happy with that? Nicola?
Yeah.
Okay, so page 6 of 24 is where the record starts. And at the bottom of page 8, I'm returning this case for reconsideration as the caseworker has considered the incorrect certificate of sponsorship. Okay. And then that's dated the 19th of November.
Yes.
And on page 9, page 10, page 11 and 12 redacted. So we have nothing till the 22nd of January.
There are unredacted.
Oh, there are
Yeah,
unredacted.
I've got
I have a hard copy if that might assist.
Yeah.
Have you got unredacted? Have you got? What have you got?
I've got redacted.
I've got unredacted.
How many copies have you got?
I have.
Let me. Actually, no. I think I do have. I think the email sent us redacted and unredacted. Let's just have a look.
These came in the emails in the last few days.
I've got. Yeah.
Yeah.
No, I'm looking.
Wait a minute, let's just double check.
On the email sent to yesterday, sent by my clerk sent it to me yesterday, just to me. To you. Would you like me to forward you my email?
Let me just see. I might.
I'll send it to you.
It's all right. I've now found the unredacted
Unredacted.
pages. Yeah.
Okay.
I say unredacted. There are personal names.
Yes.
There are names, but yeah, fine. Okay. All right. So where were we? Page 12. Page 13.
Before we move off page 12, can someone help me, please? What does GVR stand for?
Yes.
It's just,
Top of 11, for example.
yeah, and 2 paragraphs down on page 12.
My lady, I can apologise. That's something that strikes me every time I look at these records, but I haven't got to the bottom of. I can seek instructions whilst we speak.
Yeah.
I'll get an answer.
Okay, thanks.
GVR concerns. Is that the page? That's where you have. Yeah. Okay. So can you find out what that means, Mr. Harland? Meanwhile, the entry above the 22nd of January entry.
I believe. I was going to say I believe it's a genuine vacancy, but I don't know what the R is, but we'll
Right.
double check.
Okay. Okay, so the top of page 12, reason for the recon. The casework originated because of the incorrect costs. It shows me that probably there are GVR concerns due to the fact that his salary suddenly increased. I would have to request further information from the sponsor, and then sets up what the information is. And then the questions on page 13. Okay, and that's the entries. That entry is the 22nd of January. Okay. So, what are your submissions about, if any, about that entry, Mr. Burrows?
Sorry.
Well, I'm not asking for details, but basically, do you assert that this was an unreasonable inquiry?
No.
First of all, unreasonable inquiry, and secondly, that it was unreasonable delay.
No, we don't.
Okay. So the delay up to the 22nd of January was no complaints about that. Okay. So then we can go back. You happy to move on, Elisabeth? So then we go back to the other document. The sponsor sent an email on the 5th of February asking for extra time of a month
Yes.
as they were on annual leave. Okay?
Yeah.
And then on the 27th of February, an entry saying that the email had been sent to the sponsor confirming the exchange to the 25th of March. Okay?
Yeah.
Any complaints about the reasonableness of the delay so far?
Not as part of that process, no.
And then on the 22nd of March, the email was received from the sponsor.
Yeah.
With the information set out under that page. Okay? That entry is quite a lengthy entry, and it's dated the 25th of March. Okay?
Yes.
All right. Any complaints so far about the delay?
No.
Then it is being passed to the Work and Study Technical Specialist team. So that's on the 10th of April. Entry is. Okay?
Yeah.
And then the next note is the 8th of May. Okay? And then an analysis, lengthy analysis on page 16 and going over to 17, dated the 20th of May. Lengthy analysis.
Yeah.
In which the officer sets out his or her concerns about the structure of the company.
Yeah.
Any complaints so far about the...
Up to that point. Up to that point. No.
Okay, so that's the 22nd, 20th of May. Okay. Do we get a clue as to when the compliance visit was from the entry we've just looked at?
My lord, no.
Was it before this note of the 20th of May?
At this stage, there are still correspondence going on between and research from public sources, accountants.
Okay, but on the 12th of August, so we've now come down to the period of the 20th of May and the 12th of August, looking for the challenge to the reasonableness for the delay. On the 12th of August, post-decision case taken of previous post-decision CW. According to the notes, during the compliance visit, the sponsor told the compliance officers the post was no longer required. Okay. And that visit was after the note of the 20th of May, was it? Do I read that right? It wasn't before the meeting of the 20th of May.
Sorry, Mr. Holland, are you able to answer that question?
I wasn't.
Sorry.
I'm sorry, my lord. I simply didn't know it was being addressed specifically.
No, it was my fault. I was looking at my screen
But,
in the new way.
what we can see above that, in my respectful submission, in the 20th of May 2019 entry, is the correspondence. So it talks about according to information
Okay,
provided.
Would it be right to say that's a preparatory internal note, rather than the reference of any discussions?
Yeah, my lord, it's an assessment of the information that has been provided so far.
Okay,
As
fine.
I understand it, if that had assuaged all suspicions, then there may not have been any.
So, as doing the best we can, the compliance visit referred to in the note of the 12th of August was between the 20th of May and the 12th of August. It was not before and not after. Okay. Fine. All right. So between those two dates, Mr. Barrett, there was a compliance visit.
Yes.
Okay, so now you're developing your argument that the delay was unreasonable.
Yes.
I
Exactly.
reminded you that you conceded that up to and including the 20th of May, the delay wasn't unreasonable. So what is it that happens that makes it unreasonable?
Well, my straightforward point is that the respondent had all the information that was required from the sponsor to make a decision on the appellant's claim, or certainly should have been in the position, taking into account the need for expedition, given the background. There's substantial information we said has now been provided, and there's no good reason, as far as the documentation establishes, as to why a decision wasn't then made.
So that's on the. So your submission is the respondent could and should have made a decision on the 20th of May. Is that it?
Oh, shortly afterwards, yes.
Right. Okay.
Yes.
Well,
And that would have been prior to any decision, unilateral action from the sponsor.
well, it's quite clear, isn't it, that the author of this note of the 20th of May had concerns about the validity of this.
Well, there's two aspects. We said by this stage, there's apparent is concerns, but are they concerns directed to the appellant, or is it wider concerns about the sponsor?
Well, what the author of the note says on page 17 is the concern I have is whether this company genuinely needs another individual in a management role, given the company has so many already.
Well,
That's a concern directed at your client, isn't it?
yes, but that's where I go back to the fact that seems to ignore his past history. He was working in the same position previously. He had a history of working as an account manager for the sponsor. So there seems to be, I don't know, it's difficult to understand that point that's taken there, given the background, the appellant's background.
This doesn't sound like a... Sorry.
Sorry, I think the difficulty is this, isn't it? That we're all struggling to interpret what may be said to be inadequate notes.
Yeah.
And this is, after all, a permission application, isn't it?
But the point you're making is not directed at so much at delay, is it?
Well,
It's two parts. The delay, as I said, the delay overlaps with it.
Yeah.
yeah.
All right.
Procedural fairness.
Anyway, after this, you say that that at that point,
Yes.
by the 20th of May, the decision should have been taken.
Should have been taken shortly afterwards. There's no reason we can see as to why a decision wasn't shortly taken after the 20th of May.
And you say that after the 20th of May, that's really where the damage starts.
Correct, because that's where the sponsor starts to presumably consider. Well, that's where there's certainly the circumstances have changed.
Well, as I see it, this note of the 20th of May doesn't set out what the author is going to do about it. It just sets out his or her concerns. It doesn't say what happens, what plan,
No.
action plan. And then there's this entry on the 10th of June, please see person's notes. We don't know what that means.
That's why I said these notes are inadequate.
Yeah. Well, they're incomplete. I mean, if person's notes means another note, then we haven't got the whole notes. I mustn't speculate. But then we get, and then we get the 12th of August, which is an ex post facto note, isn't it, Mr. Barrett?
Yes.
And there are clearly other notes in existence because it says according to notes during the compliance visit.
And there may or may not be the notes referred to on
Yeah.
the please see person's notes. They probably are.
So the position is this: we are attempting to work out what was done on the basis of notes that are, as my lord has said, inadequate. I beg your pardon, incomplete.
Yes.
And insofar as they are complete, I would suggest inadequate.
Yes. So, well, absolutely, they don't shed enough light on
No.
the factual circumstances.
Yes. Again, speaking for myself, and the reason we're all speaking for ourselves is because we're all swimming separately in the murk here, is that I don't feel this is so much a delay point.
That may well be. Yes, I consider forcing that. As to not if it was just delay, but there isn't. As I said, that's why I'm trying to be careful. We said there's an overlap between the time it takes, because that's the process that the respondent is taking. It's taken a long time to consider the application. We say too long, whether that's unlawful or not. But in terms of the delay, that gives rise to a change of circumstances, or is more likely to lead. The longer the delay, let's put it this as far as the appellant case is concerned, the longer the delay, the more likely it is that there will be a change of circumstances, either from the sponsor's perspective, maybe even the applicant's perspective, the appellant's perspective, because he is in a position, to remind you, where he doesn't have leave to remain. He was previously working. And also, of course, the respondent. So any one of those circumstances, the longer the delay is more likely to have changed. And of course, if you're asking rhetorically, a sponsor 12 months on from when the application is made, is this vacancy still required? You haven't had your employee for 12 months. What have you been doing? I mean, there's a number of questions that arise, but of course, these are matters as regards the circumstances that are more likely to occur, and that is why, in a points-based, we say in a tier 2 points-based application, cases are supposed to be dealt with quickly and expeditiously.
Well, what support have you got for that proposition in the authorities, or in the guidance, or anywhere else?
So, I mean, it's not directly on point, but just by way of guidance, by way of background, it's page 341
Of what?
of the authorities bundles tab 18. Sorry, straight away. I mean, what I turned to even though I conceded the point about the validity of the certificate of sponsorship, there is the fact that it's specified that a certificate of sponsorship should specify or should have an employment that commences 3 months after the date of application. We say it's indicative of the fact that there's certainly a connection between having a certificate of sponsorship and employment to commence within a relatively short period, within 3 months. As I said, it doesn't mean that the certificate of sponsorship becomes invalid.
No.
But it certainly suggests there's a connection between having a certificate of sponsorship and the respondent being an individual. You can't go on forever, in other words. You can't have employment starting 6 months, 9 months, 12 months after the application, which is so we say indicative from some certificate of sponsorship itself. There's certainly an indication there as to how quickly application should be dealt with.
But just as I understand this point, you're not relying on anything else in the guidance, or are you?
Sorry, my lady.
Sorry.
I think it's fair to say there's no guidance that specifically sets out that an application will be considered within a time period.
Right.
Well, where we've got so far is that you've accepted that there's nothing unreasonable about the delay up to the 20th of May. On the delay,
Yeah.
you're still on the delay point.
Right. Yes, exactly. And so my point is that after that time period, the delay becomes unlawful. That's my straightforward submission. Because the respondent, having, I'm not going to repeat everything I said about the context, but the context then needs to be borne in mind. A decision should have been made either at that date or shortly after that date.
And is there any authority in the public law context that that supports the proposition that delay in and of itself is unlawful and something for which the court should give a remedy on an application for judicial review?
Well, certainly we would say that if that delay is unreasonable.
Or do you accept the Mr. Justice Collins' phrase of manifestly excessive in the FH case? That's the only authority we've been referred to, I think, on this point.
I think what we would say about delays is what is reasonable. Look at FH. That doesn't deal directly with my lady's point, but depends on the circumstances.
Which particular passage are you relying on?
I think it's paragraph 8.
Paragraph 8.
In FH. That's my electronic bundle, 47. But I think it may
Tab
be
4, page 40.
43 in your paper, but paragraph 8 is 43. What is reasonable will depend on the circumstances.
Yes, and so if I could first look at page 43. And of course, this is done in the context of convention, right? So to accept that. And there's reference to Lord Justice Conworth's judgment at paragraph 51. Delay may work in different ways with different groups, advantageous for some, disadvantageous for others.
Sorry, Lord Justice Calmer's judgment in which case?
Sard.
Right. Okay.
Yes, Sard, I'm grateful.
Which tab is that in the bundle?
It's tab 4.
No, I'm
You're
sorry.
looking at the
fault
citation.
is
Oh, you're looking
mine.
at the
I'm sorry. The
citation,
fault
sorry.
is mine.
So
If
sorry.
you're referring to Carnworth, it's the Secretary of State and S.
Yes, thank you.
It's cited in paragraph 7 in FH.
Right.
And 51.
Sorry.
51 of S is at page 33, which is tab.
Okay. Do you want us to look at S as well?
If my lady, if you wish, my lord.
Well,
That's-
it's a question
just-
of whether you'd like us to. I mean,
Well, yes, but, please. So paragraph 51, page 33. Tab 3. And this is in the context of asylum applications, of course, but it's and it refers to the fact that applications should be dealt with within a reasonable time. That says little in itself. It's a flexible concept. And then it kind of go back to tab 4, and FH, paragraph 8, page 43. Point being made is what is reasonable will depend on the circumstances. It's not possible for the court to say that a particular period of time should be limited what is reasonable.
Manifestly unreasonable. Paragraph 13 FH.
Yes. Yes, it is only if the delay is so excessive, grateful, as to be regarded as manifestly unreasonable.
But for my part, I think you've got to show, well, maybe that's pretty strong. I'm interested to know whether you can show prejudice specifically as a result of the delay.
Yes.
And what do you say that is?
The prejudice, well, the prejudice and the delay was, our submission on that is that the prejudice is the longer the delay, the more likely it is that the vacancy will be withdrawn. That's the prejudice to the appellant, which is of course what occurred.
Of course, it's not a vacancy because your client's already in post.
He was. Well, exactly.
Well,
It's
except
not a classic vacancy in this.
he can't have been in post because he didn't. He was an overstayer, so he couldn't have been working.
Well, my case is that he was previously in the post, and therefore this isn't a switching case. This is an individual who had been in that post.
But if I understood correctly, that at the time when he made application 2,
Yes.
he can't have been working because he didn't have leave.
Well, that's right, but the vacancy wasn't a fresh vacancy. It wasn't a new vacancy. It was the position he'd been working previously. That's why my point was earlier that is in effect an extension application, albeit except it was an application made when he didn't have leave to remain.
All right.
But
I'm just trying to understand the facts. I just want to make sure
No,
I
thank you.
understood the facts correctly. All right, thank you. All right.
Okay. So, anything else to say on delay?
I don't think I've anything else.
Okay. So we move to ground 2. Because does that deal with ground 1 and 4?
That deals with ground 1, yes. Yes, I would say it does.
And ground 2. So moving to ground 2.
Right, so, well, what we say about that is that our main, I suppose, is the procedural impropriety point. And it's the point that we say is that ultimately this is a situation where the appellant should have been given warning or been informed
Of what?
about the circumstance, the investigation, the gist of the investigation that was being undertaken. He had no idea, based on the materials that he had. And we say that's important, again, taking into account the context. On the face of it, we say he could have, having worked with an employer before, this is about a salary rise, his expectation would be, we say not unreasonably, would be that his application would be successful. There may well be other factors that came into it, but as far as his application was concerned, having worked with an employer before the same position, yes, the salary rise may well lead to inquiries to be made. I'm not saying that's something that couldn't be foreseen, but ultimately he wasn't told, he wasn't given any information until there was a withdrawal of the sponsorship.
But what would be the point of giving him information about the investigation?
Well, it's the point about, well, it would have allowed him to take, to be aware that there may well be an issue with the employer. That would allow him to take whatever steps he chose to do.
Well, what steps could he take? Because he's an overstayer, so he can't make another valid Tier 2 application, can he?
Well,
I mean, I'm just trying to understand what your case is.
Well, he could attempt to make another application, seek to vary his application. He could seek to do that. I know I understand he's an overstay, but I don't think he's precluded from seeking to vary an application. Of course, he would have to obtain another certificate of sponsorship, and that may well be difficult if he's an overstay and he's not within the 14 days. Accept all of that.
Well,
but he may take steps to say, well, look, I don't want to remain in the UK anymore, for instance, or I may want to get my house in order, but we shouldn't try and second guess. My submission is you shouldn't try and second guess what steps he would have taken. He wasn't given that opportunity.
what steps could he have taken to get leave to remain had he been notified of the investigation?
To obtain leave to remain?
Yes. Well, that's the ultimate. That's the question.
Well, he didn't have a certificate. He didn't have a certificate of sponsorship for another employer at that stage, so he would have had to obtain another certificate of sponsorship.
Could he have got that lawfully?
I think there was some difficulties with that.
Well, as a matter of law, could he have applied for? Could he have produced another certificate of sponsorship out of time?
I'm not sure he could because he wasn't. I'm not sure he could.
No. Okay. Yes. So what? Isn't that the question? Never mind about putting his house in order and left the UK. For my part, I don't see that adds to your case. But what could he have done to affect his prospects of getting leave to remain had he been informed of the investigation?
Well, he could have spoken to the employer. He could have asked. He could have spoken to the respondent and said, "What's the issue? Is there anything I can help with?" Because if the point is about it being a genuine vacancy, it may well be he could have been of assistance in that way, but he wasn't asked.
But how could he help with that question, given that he, by that stage, because you say up until May, the delay there was nothing to complain about. So by May, he hadn't been working for this employer for many months. How could he help with the question whether the employer had a genuine vacancy?
Well, he could have referred to his past experience working for the employer. He could have given chapter and verse on what he'd done. If it's a genuine vacancy, surely one can look at his past history of work and whether he'd worked. Because, as I said, we're talking about genuine vacancy, but the point is that it's effectively a continuation of his previous role, albeit at a higher salary. And it's difficult to understand why he wasn't asked anything in respect of that past history. Of course, it also works from the other way as well, in terms of the sponsor circumstances. In terms of the sponsor, if there's no
Sorry.
Sorry, my lady. I just realised that I'm going to tell a point any further. Sorry.
Oh, okay.
Apologise.
Are you going to take us
Yes,
to an
so-
authority
Yeah. So apart
which
from
cites, which
yes, if I may. So if
supports your submission on this?
Yes. So if I can take to page 200, tab 15. It's the decision of the Supreme Court in Appellant. It's page 246. And you'll see.
Has this decision not been? Oh, hang on.
Tab 15, my lady.
Tab 15. Has this decision not been reported in an official law report?
I'm sure it has.
I can answer
Yes.
that question. It's reported in the first edition of the weekly law reports.
It was a rhetorical
The-
question.
Yes.
And that was it. And the rules in this court, and I think generally, are that authorities are to be cited by reference to official law reports with helpful headnotes, rather than just the reports on Bailey, or as now going to happen, the National Archives version. And the reason for that is that in trying to get on top of case law, it's helpful to have the editor's headnote, particularly in a case like this, where I'm trying to work out what the ratio is not as straightforward as it is in some cases. Okay? So we're struggling. We do have a helpful summary, I think, in Lord Briggs's judgment, even though he was in the minority. Anyway, what do you want to? What passage in Pathan do you want to refer?
I wanted to refer to it's paragraph 72. And that starts at 245. In my view, the duty of procedural fairness requires the Secretary of State to give a meaningful opportunity to take steps in the light of the information supplied to him.
I'm so sorry, this is my fault. Which paragraph again, please?
72.
72. So is this the judgment of Lady Arden?
Yes, I think it is.
So it says at the beginning of her judgment she's partly dissenting.
She is.
Right.
But I'm going to go on to it's the last part of 72, if I may,
Okay.
on page 246. However, I agree with Lord Kerr and Lady Blythe that the duty to give notice of decision to someone who will be adversely affected by it cannot be defined solely by the consideration that it's pointless for that person to make representations with a view to reverse and avoid an effect of that decision.
So this is a duty to give notice of a decision to someone who will be adversely affected by it. So what do you say, which decision in this case does that apply to?
Well, in the context of this case, it was about a decision, of course, because the decision had already been made. But except there wasn't there'd be no point in telling the appellant about, because the decision was already made when the.
Sorry, which decision? I mean, I'm
There
just
is-
sorry.
there
I'm
is-
just trying to understand how this statement applies to the facts of this case. So what decision did the Secretary of State have a duty to give notice of on your case?
Well, we say the decision by the decision that has been taken or certainly been communicated by the sponsor to the respondent that it was deciding to withdraw the certificates of sponsorship.
Suspend.
Withdraw. I think it was with this.
No,
sponsor-
withdraw.
Withdraw.
I'm sorry.
Withdraw.
So you're not saying the Secretary of State was under a duty to tell the appellant that she had suspended the sponsor's licence. You're saying the Secretary of State was under a duty to tell the appellant that the sponsor had withdrawn the certificate of sponsorship. Is that your
I'm sorry.
submission?
I'm saying both. I'm saying both.
You're saying both. Right.
Right.
Just
I'm
me-
sorry, I
just want to
misunderstood
under-
your point.
I just want to understand what your submission is. So, Secretary of State duty to tell A, 1, decision of sponsor to withdraw COS, 2, SOS decision to suspend licence. Is that it?
Yes, it is.
Right.
Where's the authority for the withdrawal point? Is there authority saying?
I don't think there is authority for the withdrawal point.
Because the withdrawal decision is a decision made by somebody other than the Secretary
That's
of
right.
State, isn't it?
That's right. Yes. But it's a decision. Yeah, it's not a decision of the respondent exactly.
No.
Well, do you have any? There's no authority for that. Is there any passage in the judgments in Pathan which you would pray in aid in support of that submission? It wasn't the point arising in Pathan, but do you want to cite anything which indicates your submission is correct?
Yes.
Mr. Burrett, at 55,
Yes.
there is a quote from the authority of Doody, the well-known passage
Yes.
from Lord Mustill.
Yes.
You've got 2 points in that at 5 and 6.
Yes.
Fairness will often require that a person who may be adversely affected by the decision will have an opportunity to make representations on his own behalf.
Yes.
And then, until the person knows what factors are available, he can't make worthwhile representations. And at 56, it deals with the specific position of Mr. Pathan. It is not the same as the position of the appellant in this case. It's a revocation, but on the other hand, it's dealing with revocation. And the second point you're relying on is suspension, is it not?
It is. Yes. Thank you, Melody.
Okay, so in the passage from Doody, it's point 5 and 6.
5 and 6. Yes.
And then paragraph 56, relating specifically to the facts of Pathan, which it is said deals with the revocation, whereas here what is dealt with is a suspension.
You're going to respond to my lady's observation.
Yes. I'm sorry. Yes, I'm grateful. Yes. So, yes, Pathan is dealing with, of course, dealing with revocation.
Yes.
But in this case, the respondent didn't give the appellant the opportunity of an adverse decision, or have the opportunity to make representations in respect of the likelihood that the sponsor is going to withdraw the certificate of sponsorship, or indeed the cancellation of the licence itself. He was given no opportunity at all. And he wasn't given any meaningful opportunity to take averting action. He wasn't given any extra time to try and put himself back in the position that he should have been, that he was in initially. So that position being where he was able to make an application under 39E. He wasn't given that opportunity, or given a time period, a discretionary time period, in order to take steps to put himself in a better position.
Well, am I right? Again, forgive me if I'm wrong. The appellant in Pathan was not an overstayer.
That's correct.
There was, there was a in the Court of Appeal. There was another appellant, wasn't there? Was it Mr. Forgive me.
Yeah, Mr. Islam. Yeah.
Islam,
Yes.
who was an overstayer.
Yes.
Given Mr. Pathan's position, it wasn't an overstayer. That's the context of paragraph 56, isn't it?
Yes.
Because it was right that such an applicant should have the information to avert or mitigate a potential fatal blow to his application. How do you say that applies in the case of an overstayer like Mr. Islam and your client in this case?
Well, we say it's probably just as important that the fact that he's an overstayer is this is the point that this is the only application you could have made. We've already covered that, right? Because he had 14 days to make this one application, you can't make a second application. So it's just as important, we say, in those circumstances, particularly given the background. That he is given an opportunity to avert the potentially fatal blow to his application. Now, it's a matter for the Secretary of State how to deal with that, whether they give him 60 days or. But firstly, they didn't give him an opportunity, so firstly give him an opportunity. On the one hand, it might be dealt with the appellant giving further information by assisting the respondent, but on the other, it may be that he decides to take other meaningful steps, such as make a new application if he's given the opportunity to do so.
Is there an obligation to notify an applicant of the revocation of a certificate where the applicant is an overstayer?
No. Where is an overstayer?
Yeah, so where the applicant is an overstayer, is there an obligation on the Secretary of State to notify him of the revocation of the license?
Well, I don't see why there shouldn't be an obligation in those circumstances.
Well, what about? I mean, that wasn't the circumstances in Pathan.
It wasn't.
And isn't there authority of this court to the contrary? Raza.
Yes, Raza, yes.
And also Pathan in this court dealing with the other appellant, Islam.
Yes, in Raza we'd say Raza was different case in the sense that it wasn't dealing with, it was dealing with the students. We say that's the context of how Raza was dealt with.
Sorry, Ros was dealing with?
The students.
So Raza is distinguishable on the grounds it was a tier 4.
Tier 4, correct.
Right.
In terms of Islam, I find in Islam, that's distinguishable because firstly, there was no real delay in that case, we say, in terms of Islam. Secondly, it was a switching. I say switching. It wasn't a continuation of tier 2, the tier 2 appointment. It was a switching case, switching from one category to another. So the circumstances are very different. So and the reason I say that is because if it's a first time application, it's more likely there's going to be concerns about a vacancy.
But
for instance.
Raza and Pathan in this court are authorities for the proposition that there's no duty to notify an applicant of the revocation of a sponsor's license where the applicant is an overstayer at the time of the application.
Yes.
How does the question of delay or whether it's a continuation of employment affect that proposition?
Well, in my submission, the expectation is somewhat different because the revocation in the context of an individual who's applying for the first time doesn't have an expectation necessarily that his application will succeed. It's the
So you would say that there is an obligation to notify an applicant of the revocation of the certificate of sponsorship. Sorry, the license to sponsor.
yes,
Forgive me. The license to sponsor.
yes,
Notwithstanding the fact that the applicant is an overstayer, if there's been a lengthy delay before the decision is reached and the application is in effect a continuation.
exactly, and I place an emphasis on the continuation of the application.
Why does that impose an obligation on the Secretary of State when, as it were, a fresh applicant doesn't have that right?
Well, we say it's a question of fairness, in the sense of that.
Why is it fairer? Why is it more unfair to a continuity candidate
Yes.
than it is to a fresh candidate?
Well, simply go back to the point, because his expectation was that he met the requirements of the rules based on his past, because he was already employed by the sponsor. So he had a history. So it's the whole
Okay.
I'm relying on the whole context.
Is the reason why there is no obligation to notify the applicant where he's an overstayer, no obligation to notify him of the revocation of the license? The reason is because there's nothing it doesn't affect what he can do about it. The fact is, he's an overstayer, so he can't do anything about it. And that applies whether or not he's a continuity candidate or a fresh candidate.
He can't do anything about it unless he's given a period of time, a period of leave. So unless if he's given 60 days, then of course then he may.
Well, can he be given 60 days?
Well, it's a matter for the Secretary of State. And they say, presumably they say no, they couldn't. But
And what could he have done if he'd been given 60 days?
well, if he'd have been put back in the position he was in, then he could have sought to obtain another certificate. It would have been difficult, as it was recognised in Part 1, to obtain a new certificate of sponsorship. But he could have made an attempt or made another application. But we say it's not to second guess what he could have done.
Well, please, I'm not trying to second guess. I just know what his options would have been. He couldn't have applied for leave to remain.
No.
So what could he have done?
He could have obtained, well, his best, well, we say he could have sought a new certificate of sponsorship from another employer. If he's given leave. Without leave, he can't do that. We've already accepted that.
Sorry. He couldn't be given leave.
He couldn't, well, the Secretary of State, if they...
Is there any basis in the rules for the Secretary of State just to give somebody 60 days leave at her option? I mean,
No, I think
either there is or there isn't.
I don't think
No.
I mean, you said this isn't a challenge to the points-based system.
yes.
And the fact about the point-based system is it has harsh lines,
It does.
bright lines.
It does, yeah.
And this court and other courts have pointed out repeatedly that is a fact.
Yes.
And it's a matter which some people don't like, and there are arguments against it, but it's a clear policy for understandable reasons, which we all have to accept.
Yes. But that's why it's more important, just as important, that the respondent acts procedurally fairly. So that's because of the harshness, the potential harshness because of the positions of individuals like the appellant, because of the potential that he would be left with no leave and no opportunity to make another application. So that's why we say he should be made at least, no matter of fairness, be made aware, at least a gist of any of what the underlying difficulty is with his application. He was never told until it was too late.
Yeah, thank you.
Thank you.
Yep. Now, any further questions?
Thank you very much.
Elizabeth. Okay, thank you very much.
Thank you.
Thank you. Now, Mr. Harland. For my part, I am, and whether or not this is going to determine the appeal, or I don't want to be in firm view, but I am concerned about this gap in the notes, and I want to know what you can tell us about it.
Well,
First of all, do you accept there is a gap?
in terms of a lack of information as to what was going on with the sponsor at.
Well, I'm looking at page 17 of 24, and it seems to me that there must have been a compliance visit between the 20th of May and whatever the date in August is, 12th of August, and possibly it was on or around the 10th of June, I'm guessing from the note we've got, and we don't have the notes about that visit. See, I wonder whether, where it says, please see person's notes on page 17, that's a reference to the notes somebody took of the compliance visit.
Well, my lord, can I start off perhaps with the practicalities of these notes and then address the principle, because your lordship asked me about the principles of evidence at the very beginning of this hearing.
Yeah.
I've had some time to think about that whilst my learned friend has been on his feet. Firstly, in relation to the contents of these GSID notes, it must perhaps be recognised that what these notes are a record of the decisions taken in relation to this applicant's case. The decisions taken in relation to the sponsor would be held separately elsewhere, and of course, whilst there might be communication between the decision makers and overlap between what was known, the reality is that these notes were not designed in order to capture all of the information about what was going on with the sponsor. And of course, subsequently, had there been a decision taken in relation to this applicant's case, which turned on the suspension of the sponsor's licence, one might have expected full explanation to be put into the notes at that point. But in fact, in reality, that was superseded by the sponsor deciding to withdraw its sponsorship of this applicant. So his application failed for that reason prior to the suspension. So
Just a minute. Can that be right?
We're not sure about timings.
Well, I say it is certainly right that the principal reason why this application failed is because the sponsor had said explicitly and eventually unambiguously that they no longer wish to sponsor the applicant, and therefore they would.
Okay, but it wasn't unambiguous at the 12th of August. I have your point there, but it wasn't unambiguous because, as Milady pointed out, the note says, Lady Justice Nicola Davies pointed out, the note of the 12th of August says, I'm unsure, etc.
Yes.
So there is an ambiguity there at that point about it. So
Yes.
at that point, the decision has not been taken on that, has it?
But if one goes to the decision itself, one can see that the decision was taken on basis that the sponsor had decided to withdraw their sponsorship of the applicant. And that has to be the starting point, because if the sponsor doesn't want to sponsor the applicant, then it doesn't matter whether the suspension is going to be continued and revoked, or whether it'll be overturned and then the application needs to be looked at again. So the starting point for the decision maker here is that the sponsor is now saying, we don't want to sponsor this individual. And as a result of that, he can't succeed in his application, because how could he succeed? The Secretary of State can't say, well, you have permission to work for this person who doesn't want to employ you.
Okay, so that is to focus on the note of the 29th of August on page 18, are you?
Well, just in terms of the practicalities of what is included in the notes,
That's the note of the decision, is it? The note
Well,
of
the decision is sent.
Yes, but that's
to
the, okay.
appellant.
Fine. In the letter, well, I'm deliberately looking at this note for a reason I'll come on to. The note of the decision in these notes is the 29th of August.
Yes.
Okay, and that's recording the fact that the application has been refused on no COS. Sponsor withdrew COS. So that's where, in these notes, you're saying that confirms that's the reason.
Yes.
No new CS was supplied at the time of refusal, and then in brackets, sponsor has been suspended, not mentioned in the RFRL.
Yes.
Okay, the reason I go to that first is my question is why wasn't it mentioned in the RFRL?
Because, my lord, the prior decision, logically, is the issue that the sponsor is no longer wanting to sponsor the applicant. So no matter what happens to the suspended licence, and one must remember it had the potential to, in fact, be unsuspended down the line. In fact, it was revoked. But no matter what happened to that licence, because the sponsor said, I'm not going to sponsor you, then that is the end of it. So that is why the decision letter can take it quite briefly, because it says that the sponsor has said this.
Well, you say take it quite briefly. I mean, just looking at these notes, and if we look at page 17, the note that's dated the 27th of August, it's just interesting looking at the sequence of the note. Email received from the compliance officer, the sponsor's licence has been suspended. So that's the primary. And then the sponsor also confirmed the job is no longer available. Email PDC mailbox for direction, refusal, give opportunity for new COS. So there's a query even 2 days before the letter is sent. Then you've got email sent to AWATS, whoever AWATS is, for way forward. That's the 28th. And then on 29th, you've got application refused, the note you've gone to, and a specific decision seems to have been made, for a reason we don't know, that there has been a deliberate decision not to mention the suspension of the sponsor in the letter. It might be said those notes raise more questions than they answer.
Well, my lady, as to whether there's an obligation upon the Secretary of State to mention a suspension in a letter, we say that there can be none, because what has happened here is the sponsor has independently, separately, said that they no longer wish to sponsor this applicant, and so for that reason his application must fail. I'll accept that that isn't in my pleadings, but for the good reason, this is not an argument that has been raised, even though this appellant has had these notes for some time. They don't say that this decision was a failure for an unlawful failure on the behalf of the Secretary of State. But
the decision was not, the decision to refuse the application was not taken until after the suspension of the licence, was it?
that seems to be the case, my lord. But what we can see
Because
before,
what happened is the compliance officer says don't make a decision until informed to do so by compliance officers.
Yes.
And then the email comes through. The email received from compliance officer, we haven't got it. The sponsor's licence has been suspended. The sponsor also confirmed the job is no longer available.
So my lord, we have various different permutations that are perhaps floating around for the decision maker at this point. The first is that the sponsor's previous words shouldn't have been taken literally, and in fact the sponsor does want to continue sponsoring this applicant, in which case the decision will have to go in one way. But then we have a situation where the sponsor's licence is not being suspended, and again, it might be that if the sponsor still wants to sponsor the applicant, then again the decision maker needs to deal with that. In the circumstances where the licence is being suspended, the reality is, and we see this in, for example, the case of Pathan, what happens there is that no decision is taken during the suspension, and then if there's a revocation, then thereafter, those applications which are outstanding will be determined. And it's for that reason, perhaps, that in Pathan, their lordships considered that what was required at that point, at the point of revocation, was that the individuals awaiting a decision should be promptly informed of the revocation of the licence, no matter when their decision was taken down the line on their application. So those are the different parameters here, and it is correct that on the GSID notes that we have, not all of those are spelt out. But of course, why would they be? These are not documents which are being prepared for litigation.
So,
No, and they're not even a formal record of the decision. The formal record of the decision is at various, I mean, in several places in the bundle. For example, on a page, paginated 192, to take one at random. And the reason that's given for the decision is that the Home Office have been told in writing that there was a restructure of business and the sponsor decided to withdraw the certificate. So that is the evidence of the decision. That's what the decision says.
Various points. First of all, are you saying there's a distinction between the obligation to notify of a suspension of the licence and the obligation to notify of the revocation on Pathan?
My lord, yes. In the case of Pathan, it was only the revocation which had to be notified. There had obviously been a suspension in that case prior to the revocation.
And is it expressly said, I've not read, forgive me, every single word of the judgments in the Supreme Court, is part of the ratio that there's no obligation to notify an applicant of the suspension of a licence?
My lord, the point, I was involved in the case of Pathan. I was junior counsel for the Secretary of State in that case, and the point wasn't
I expect you to be able to tell us every single
the point
ramification.
It wasn't argued that the suspension triggered a notification responsibility, and that is perhaps because it's only at the moment of revocation that the situation has changed significantly, so that an application which would otherwise have might have succeeded is now bound to fail, and the applicant therefore would want to know of that promptly so that they can take steps. And in Pathan, the steps that might be taken were things such as preparing themselves to meet the hostile environment, for example, because that decision would bring to an end their otherwise lawful stay under Section 3C. So it was seen by the Supreme Court in that case that following the revocation, and that was a step which the Secretary of State was taking, which was fatal to the application. At that point, the duty arose. But of course, with the suspension, that we're not in that territory, because with the suspension, what is happening is that the sponsor is then being investigated, and it's only if there's a revocation that the application will fail. And indeed, it might be pointed out, as is in Pathan, I wouldn't turn it up, Mr. Burrett can correct me if I'm wrong. There will be a different outcome depending on whether an individual has been thought to have been involved in the reasons for the sponsor's licence being revoked or not.
Yes.
If someone is complicit in a fraud and can be shown to have been complicit, then they will have less procedural fairness obligations due to them than if they are simply an innocent bystander. And can I say this? It's not being asserted in this case that this appellant was involved in the fraud. We don't need to go that far because we stopped at a far earlier stage.
What do you say to Mr. Burrett's response to my queries about Razar and Pathan in this court? In other words, he says that they're distinguishable.
My Lord, with respect to him, I think he may go further. I think he may say that there is an enhanced duty in an
He does.
overstayer case, because
does.
an overstayer has
Yes.
less chance of rectifying their position. With respect to my learned friend, that simply cannot be right, because what we have, the distinction which is there. Rather, I'm sorry, I'm always come up my notes because we're rushing upon this faster than I
Sorry.
anticipated. But in Pathan we have
We're getting Pathan in the Court of Appeal.
I say, well, we can start with Pathan in the Court of Appeal, my lord. And if we turn...
So that starts at 169, the electronic bundle.
Grateful, my lord. And the relevant paragraph is at paragraph 51, so page 181.
So 169, the paper bundle.
181 of the paper bundle, but paragraph 51 within the Court of Appeal judgment.
Paragraph
51 within the judgment. That is Pathan looking back at Raza.
Yeah. This is Lord Justice Singh, isn't it? Yes.
And what that refers to, it notes that he's a student. Mr. Raza was a student, but the court in Pathan, this court in Pathan, didn't think that that was a material difference between the two. And it went on to say that Raza distinguished the case of Patel because it was distinguishable on its facts. That is because at the time when the appellant made his application to extend leave to remain, he was no longer any lawfully present in the UK with leave to remain as a student. And then at paragraph 52, the decision of this court in Raza presents a formidable difficulty for the second appellant, Mr. Islam, as Mr. Biggs fairly acknowledged. Mr. Biggs sought to distinguish Raza, but I'm not persuaded it is possible to do so. In my view, the essential reasoning of Christopher Clark in paragraph 16 to 17 applies equally to the case of Mr. Islam in the present case. And it might be noted that if one turns back to paragraph 16 of the judgment, that those are the facts of Mr. Islam's case.
Yes.
Mr. Islam, on all fours with this appellant, was someone who had made his further application within the 14 days permitted to him, so that his application would not fail for that reason alone. So Mr. Islam was in exactly the same position as as this appellant. His case failed in the Court of Appeal for the separate reason to Mr. Pathan's, that he was an overstayer. And of course, we know that Mr. Pathan sought to appeal to the Supreme Court, and Mr. Islam's appeal simply didn't reach the Supreme Court because his case was distinguishable. And there's nothing in the Supreme Court's judgment which cast doubt on that distinguishing factor. And the reality is, again, going back to what was before their lordships in Pathan, the distinction is between someone who has made an application that the Secretary of State unilaterally causes to fail, without them knowing anything about it, which is going to throw them into what was described in Pathan as a hostile environment. And there is the distinction between such an individual and someone who is an overstayer, but who's made an further application through the grace of the Secretary of State, and therefore is not going to be newly subject to the hostile environment by way of the application failing. Now, my learned friend has said on a number of occasions that this applicant had an expectation that his application would succeed. And again, with respect to him, that cannot be correct. There is no legitimate expectation or any other kind of expectation that one's application will succeed. All that one can anticipate is that the decision will be taken lawfully on the basis of the facts and policy at the time of the decision. And so facts can change, policy can change. And whilst an applicant might be taken by surprise by that, they can't come to the courts and complain of unfairness as a result. So it can't be the case that this applicant had built up an expectation that he was going to succeed, because as an overstayer, he had put in an application which the Secretary of State subsequently found to be ill-founded. So there is no authority that supports my learned friend's position. To the contrary, there is clear authority which distinguishes between the cases in Pathan and his individual case. But I don't base my submission solely on the fact of him being an overstayer. I also, as you'll have seen, my lord, from my submissions, point out the other differences between the case, and in particular, the key difference that this application turned on the decisions taken by the sponsor whilst the investigation was ongoing. And that is a separate but equally valid reason why this applicant must be distinguished from the appellants in Pathan. I can take your lordship to the cases of EK, Ivory Coast, and in particular the case of Topada.
Yes.
That would assist.
Well, for my part, I've looked at Topada, but do you want to, and EK? We all have. What do you want to show? Do you want to show us anything? Or
Can I just, without perhaps necessarily turning up the authority of Topada, just stress how similar it is, insofar as that was a case where an applicant had made a Tier 2 application, as this applicant did. He had, the Secretary of State had concerns about the genuineness of the vacancy, and had written out to the sponsor to find out their answer to the question. So the first stage of what is actually quite a complex process that we see playing out through the GSIP notes. And the sponsor hadn't responded. And the net result of that is that if a sponsor doesn't respond in time, the Secretary of State is entitled then simply to refuse the application, and that is what they did. And what was being argued in that case was that where a sponsor is under investigation, the applicant should be informed, because they then have the opportunity to perhaps chase up the sponsor or whatever. And the court...
This is Lord Justice Lewis, isn't it?
It is, with delivering the leading judgment. Considering Pathan, having been directed to the Supreme Court in Pathan, distinguished it in particular, and I'm looking at page 307 of
yes, paragraph 58.
56 to 58.
Yeah.
And perhaps a ratio stated very clearly at the bottom of paragraph 59 at page 308. I do not consider that the majority decision of the Supreme Court requires the imposition of a duty to notify an appellant of a request for additional information and evidence as sent to a sponsor of an applicant for leave as a Tier 2 general migrant.
So where were you reading from then?
The last 3 lines of paragraph 59, last 4 lines, it says, in those circumstances, the sentence begins, I do not consider that the majority decision. You have that, my lord.
Yeah.
And frankly, as this case was not put before the learned judge below, but had it been, it must be that that is a complete answer to the case as it was put before him, which is that there was a duty to notify of the investigation. And indeed, that is the case as it's been put in this appeal, that there is a duty to notify of the investigation.
Um, I'm just reading the rest of Lord Justice Wilson's comments at 58, 59. So you say, well, do you say this case is fully on all fours with Tapada?
My lord, I do, when it comes to the decision to investigate. It clearly is on all fours. More than that, of course, it also tallies with the EK Ivory Coast case law, which distinguishes between decisions which are taken by the Secretary of State and decisions which are moved by the sponsor, or actions which are carried out by the sponsor. And so one can see that in the case law, one has EK Ivory Coast, one has Torquada and Topada. One has cases where indeed the applicant's sponsor has made a mistake, potentially induced by a lack of clarity from the Secretary of State or whatever, but the fact that the prime mover in those circumstances is the sponsor distinguishes it very materially from the Pathan cases. And so one has to remember, I would respectfully urge the court, that the Pathan ratio remains relatively limited. And we can turn that up. It's in paragraph 265 of the judgment, which is behind tab 15. And I'm sorry, I said 265. It's actually on page 265 of the paginated bundle, and it's paragraph 143.
Well, it's where they're really saying this is what this is about.
Yes. And the distinction is being made between what I've called in my submissions prompt notification and prior notification, although I think that terminology in fact came from Lord Kerr. And the prior notification is what perhaps my learned friend is seeking in this case, the gift of a certain amount of time after notification of a decision by the Secretary of State. My learned friend has suggested 60 days. And it's true that those 60 days historically were what were given to students whose university or whose college sponsorship was cancelled. And that flows through the Patel case law and the EK Ivory Coast case law, and we can go to it. So, but the case of Pathan was saying that not that there needs to be prior notification. So it doesn't need to be a gift of a certain amount of time. They reached a conclusion that that would be an issue of substantive unfairness, which they didn't find. But what they found in that case was that in the specific circumstances of Mr. Pathan's case, where there had been unilateral revocation by the Secretary of State of the license, there was an obligation of prompt notification. So that meant that it wasn't appropriate for the Secretary of State, as she did in that case, to wait around for a number of months before notifying the applicant that the sponsor's license had been revoked. But no such obligation can flow from the suspension of a license, and in any event, that is not why this application fails.
So I'm looking at the distinction, looking at, this is Lord Kerr and Lady Justice Black, isn't it? Lady Black, forgive me.
Lady Black, yes.
Forgive me. The distinction between 2 and 3 in paragraph 143. The majority held that there was a duty on the Secretary of State to notify the appellant promptly of the revocation of the license.
Yes.
That was the majority. That was 4-1.
Well, it may have been 5-0. But
At least 4-1.
in a non-clear, in a perhaps slightly
Doesn't matter.
difficult.
But then a different ratio. Different. 3 of them. Lord Kerr, Lady Black, and Lord Briggs held that there was no positive obligation on the Secretary of State to provide a period of time following notification to enable an applicant to make an alternative application, or otherwise to react to revocation.
Yes.
So that's why you say it was a very narrow.
I do, my lord. So there
And
are.
if in this case, it's the positive obligation that's relevant, do you say? The absence of a positive obligation is relevant because
Yes.
the applicant couldn't have made an alternative application.
As an overstayer, I'll defer to my learned friend as the practicalities of doing so. It seems that he would have struggled to get a new certificate of sponsorship.
Okay.
As a matter of law, the question is what would have happened if the Secretary, if he'd varied his application and provided the Secretary of State with a new certificate of sponsorship, varying his old application. As far as I'm aware, this point hasn't. I'm afraid I haven't pleaded this point because it's somewhat new to today. But had there been a variation of the application, it seems to me there's a dispute of law in the cases that I've seen as to whether that would have, the variation of the application would have put him out of time. But in any event, the case law is strongly against my learned friend simply by virtue of him being an overstayer anyway. It's not a question of practically whether he would have had an opportunity to do anything different. The key point that the courts have relied on, and one can see that from Raza and Islam in the Court of Appeal, is just the difference in his status prior to that, the difference between him being someone who was exposed to the hostile environment as an overstayer and someone who wasn't.
Thank you.
So with respect to my learned friend might have it, I would say backwards. He says that there's a heightened obligation for overstayers. We say no, that it simply isn't that, because an overstayer has already had the opportunity to continue their leave lawfully, and they have failed to do that, whether by mistake or blind failure to comply. But the Secretary of State doesn't need to give them a second chance at that. My lord, a long time ago, and I'm aware that I've been on my feet for some time, I said that I would address the practicality of the notes first and then the principle as to what should be put forward at a permission hearing. Your Lordship asked me about that earlier.
Yes.
Would it help if I touched on it quite
Yes.
briefly? What I think we would say is this. When an applicant for judicial review brings their claim, it's for them to set out their case. That must be done. And they can do so by pointing to, if they say a decision has been irrational, pointing to irrationality on the face of the papers, or by pointing out specific decisions that they say were irrational. And sometimes they'll have that information, sometimes they'll need to obtain it from the Secretary of State. But nonetheless, the obligation falls on them to make those inquiries. If they say a certain bit of information is crucial to our case, we would want to see it, then the Secretary of State will comply with any such obligations that are on her. So when the case is brought, the principal obligation lies on the applicant to say why a decision is irrational. That perhaps is trite.
Yeah.
The second point is a principle that I alluded to earlier, which is that all things being equal, if there is a dispute of fact, then the dispute of fact should, in the judicial review sphere, be resolved in favour of the defendant to the judicial review. so here the Secretary of State. But one must accept that in cases where an appellant has, or an applicant to a judicial review has raised a case which calls for an answer, then the respondent will have to answer that at some stage. And they would normally answer it in relation before the permission hearing if they want to defeat it at the permission hearing, or they can subsequently raise it at the substantive hearing if it gets that far. In this case, there are certain points to observe. The first is that the applicant says, in essence in their case, that the delays were a failure on the face of it to follow the policy. And Mr. Burrett hasn't pursued them this morning in court, but on the stated case they say that that is, for example, a failure to conclude the application within the indicative period of 10 working days or 4 months or whatever. And I can take your lordship to that in due course to show why that, with respect, is a complete misreading of the policies. But that is the argument that they advanced. They said that this was an excessive and this was a period of delay based on those reasons. They didn't obtain the GSID notes. They didn't seek them from us. And those notes, therefore, those notes weren't before the judge below.
And nor did he request them?
No. I'd be correct if I'm wrong, but I don't believe there was any request made of the Secretary of State for those GSID notes before the...
The first time the request was made was I made it.
My lady, yes.
Because I was concerned about the absence of any real response from the respondent.
Yes. And my lady, one can see that in terms of judicial reviews, a judge at first instance would be at a permission hearing would be best served by having all of the evidence before them. Of course, as a matter of practicality and by the very nature of oral permission hearings in the immigration judicial review context, those are not always going to be produced to deflect any argument that is raised at the oral permission hearing. But of course, my lady, I hear what your ladyship says. These notes do help establish what was in fact going on behind the scenes, and it's for that reason that they are helpful before this court. Of course, they are still not everything. There will be other documents as well. I don't doubt, which set out what was happening in relation to the sponsor. But in relation to whether this appellant has met the principal primary onus on them to saying, is there manifestly excessive delay in this case? The notes that we have, and indeed I would say that the letters that we have in the bundle, but in particular with the notes added, assist this court to properly answer that question. Because my learned friend, with respect to him, we say cannot point to a specific point of delay. Insofar, going back to my skeleton argument, one point that I hope to emphasise in that was the nature of the Tier 2 process and the importance within that process of trust being placed on the part of the sponsor to comply with their sponsorship duties. My lord might remember that I took the court to the case of Raj and Kroll, which talked about the light trigger that was there for the respondent to investigate, potentially the obligation that she had to investigate any potential breaches. The Secretary has to get it right, because of course if what she does is prematurely go into this evaluation and say, well actually I'm going to revoke the sponsor's licence, she may get challenged. Whether or not she succeeds in rebutting that challenge, there will be an impact on the employees, on that company and its ability to trade. Likewise, if she goes headlong into the assessment and doesn't carry it out thoroughly, she lays the system open to abuse. So she is entitled, I say, clearly, to take reasonable amount of time and to carry out the investigations thoroughly. And one can see from the notes that this is not a straightforward phoning someone up and saying, are you complying with your sponsorship duties? It has to be something more than that, and that involves assessment of accounts, assessment of the company structure, and assessment of the company on a visit. It can involve the assessment of a company on a visit.
So what do you say about the point made by Mr. Burrough that looking at it in context, there is already a delay of 2.5 months, which has to be at the door of the Secretary of State by reason of the initial wrong decision. Against that background of delay, it was incumbent on the Secretary of State to act expeditiously.
Well, my lady, can I address Mr. Burrows' points in two ways? Because the second response to that is looking at the case law and seeing what the rules in relation to delay are and the obligations on the Secretary of State that the courts have proposed. But prior to that, there is an issue as causation, which is specific to this case. Because Mr. Burrett, when he talks about the 2 months of delay, says, well, what one should be doing is perhaps moving everything forwards by 2 months and the Secretary of State taking a decision on the application, say, 2 months earlier. And in those circumstances, as I understand him, he is saying that had the decision happened before the sponsor had withdrawn the licence, then the sponsorship, then the application would have succeeded. But with respect to him, that can't be right, because we're not waiting throughout this time for a decision on the application. What we're waiting for is the Secretary of State's decision on the sponsor. Because until the Secretary of State has decided on the sponsor's bona fides, she is not going to turn to decide the application. And that must be right, because if the sponsor hasn't got a genuine vacancy, if they are in fact taking money from people pretending to have a job for them, and they're doing that systematically, then we know what's going to happen to the applicant.
You can't just separate it out like that. You can't compartmentalise them like that, because the Secretary of State's investigation in respect of the sponsor directly impacts on the appellant's application. And it goes back to the primary point, that when the Secretary of State embarks on that application, she's already 2.5 months behind because of the wrong decision at her door.
My lady, I didn't mean to compartmentalise them. In fact, what I say is they do come together and one can't disentangle them. And as a result of that, what one is waiting for is the decision by the Secretary of State on the sponsorship. And so whatever the end result of this, had the sponsor not withdrawn the sponsorship, we know what would have happened, and it's not that the applicant would have succeeded in his application, because we know that in fact what happened was that the sponsor's licence was suspended, and so the causative impact is nil.
So your point is it's simply not rational to make a decision on an individual application, which is an application to fill a genuine vacancy, until you've properly investigated whether the sponsor is acting properly.
My lady, yes.
Yeah.
And that can take as long as it takes. But the Secretary of State's responsibility is simply to go into that conscientiously and addressing all of the different points that are put forward by the sponsor and by her own analysis. But the causal impact here is, I say, significant, because Mr. Burrett wants to say on behalf of his client that but for the 2 months delay, his client would have succeeded in his application. And my response to that is that can't be right, because even if there hadn't been a delay, we'd have just got to this point 2 months earlier. So say that had the Secretary of State done her compliance visit 2 months earlier, then potentially the sponsor might have said at that point, well, I'm not going to sponsor this person any longer. We don't know. But my argument doesn't turn on that. Because we do know what happened, which is that the sponsor's license was subsequently suspended and then revoked. And so the outcome of this would have simply have been that this applicant's role, he simply would have lost his application would have failed perhaps earlier than it did, but it would still have failed. So I say that is a first reason why my learned friend's arguments can't succeed, because he says that there is a causative impact here of the delay, and there isn't. There would only be if the applicant.
So ultimately, this does come back to the revocation of licence point and to the distinction between Pathan and Islam. Does that follow from that? Because your long stop argument is that if we didn't have the delay and the licence had been revoked, there'd never been a question of the certificate being withdrawn. The licence to revoke would leave him without a remedy, given he's an overstay.
Yes, and I can take authority from that, for example, from the pre-action protocol response, which explains that.
So where are we in the bundle on that?
It's at page 161 of the paper bundle.
Okay, I'll find it.
And that will be the response to the pre-action protocol letter is at page 54 of the judicial review bundle.
Yeah. So I'm looking at the response at 30th of October. All right, date 30th of October?
No.
No.
Yes, my lord. 30th of October, and the third page within that.
Yeah.
And there's a Roman numeral 9, and that says if you held leave to remain when your sponsor's licence was withdrawn, you would have been eligible for a period of leave to find a new sponsor. However, you did not have leave to remain, and therefore were ineligible, as your sponsor withdrew their sponsorship before the sponsor's licence was suspended. So the point being that as an overstayer, when the revocation, if the revocation had happened, if the licence had been withdrawn, then the applicant would simply have had nothing further
Okay.
could have done. So
I think Mr. Barrett's point is that one of his points is that if they had if this had all been done more quickly, the licence might not have been withdrawn.
the sponsorship, he says, might not have been withdrawn. But my
Right.
point is a slightly different one, I hope, which is that what I say is that the
Okay,
I'm
sorry.
looking not at the
Yes,
sponsorship.
no, you're wrong. I'm getting confused.
I'm looking at the sponsor's license, and the reality is that just hurrying this forwards by 2 months doesn't result in any different outcome
Yeah.
for this applicant.
Yes, that's your what I call your long stop argument.
It is, my lord. It's long stop, but I put it first because it's a very straightforward answer to the appellant's arguments. But then one can go on, and I do note the time.
Yeah. Okay. Well, we're obviously not going to finish. How much longer will you be? Now.
I can check through my notes. I suspect, I'm afraid, I'm still going to be 20 minutes.
Okay. Fine. Well, in that case, we'll rise now and resume at 2:00. Thank you very much.